In this lesson, what I want to do is spend a little bit of time talking about the process of bringing a claim in judicial review. Talking mainly about the claimant in a judicial review case, who that claimant can be, and what relationship to the alleged violation or the alleged acting outside one's authority that a public body is actually doing, and what relationship they have to that public body or to the particular circumstances in question. So, the previous lesson spent a little bit of time looking at the concept of judicial review, looking at a number of the major requirements and some of the key elements in the process of judicial review, such as this idea of abusive process. The idea here being that if you are a claimant who has a valid claim in judicial review, it would be an abusive process to bring an ordinary piece of civil litigation against a public body, because there are certain procedures and requirements and that there are certain protections in place for public bodies in judicial review cases that don't exist in the ordinary instance of civil litigation. So this lesson is going to talk about the process of actually bringing a claim in judicial review, the person who may be a claimant, and looking at a couple of pieces of case law that illustrates the purpose of this particular area, the purpose of essentially restricting, at least theoretically restricting, the number of people who may be and may be able to bring claims in judicial review. So I've written here that theoretically, anybody can bring a claim in judicial review. Now, while that is true, what I mean by this is that theoretically there is no limit to a person who has a valid claim in judicial review to bring a claim in judicial review. But in reality, the judicial review pre-action protocols stated that a person can bring a claim in judicial review so long as they have a sufficient interest in the matter in hand. So when I say theoretically anyone can bring a claim in judicial review, what I mean there is that any person could bring a claim in judicial review so long as they have the prerequisite sufficient interest in the matter. Now, this does limit, as a result, therefore, the number of people who may be a claimant in judicial review cases. If you do not have a sufficient interest in the matter, you do not have sufficient interest in being able to bring such a claim in judicial review, then you cannot bring a claim, and the claim would therefore fail at that early juncture. There is also the ability, if you are maybe not somebody who has a sufficient interest, you may be someone who has an interesting party, and therefore you may then be able to bring a claim in judicial review along that particular merit. An interesting party is defined in the civil procedure rules as simply a person who is not the claimant or the defendant, who is instead directly affected by the judicial review decision. So this is the two general instances where an individual may be able to bring a claim of judicial review forward. Now, a key case which illustrates this point is the case of Crown versus the IRC, the National Federation of Self-Employed case from 1982. This case gives us an indication of the kind of thought processes and the kind of reasoning and rationales that a court will engage with when it comes to bringing a claim and when it comes to who may or may not be a sufficient interested party in the bringing of a claim in judicial review. This case involved a number of print workers on Fleet Street who had been granted a tax amnesty by the Inland Revenue on account that they registered their taxation affairs. Now, the National Federation of the Self-Employed, which was a union for self-employed individuals, brought a judicial review case on the basis that Inland Revenue had actually acted ultra vires in being able to grant amnesty. They brought the claim suggesting that they had acted beyond their authority in being able to grant this amnesty to these print workers on Fleet Street, and so the claim was to be nullified or to be made void. The question then hinged on standing, whether or not, specifically, the National Federation of the Self-Employed were able to bring a judicial review case on account of them having a sufficient interest in the case, or being a sufficiently interested person such that they were able to bring a case forward? Did the National Federation of the Self-Employed actually have the ability to even bring a case in the first place? The House of Lords held that the National Federation of the Self-Employed did not, in fact, have a sufficient interest and therefore could not bring a claim. Lord Wilberforce considered that the question of standing, the question of whether or not you are a valid claimant, and the question of sufficient interest ought to be considered in conjunction with the facts of the case, and that this would ultimately give a bit more of a substantive framework to the ultimate conclusion of a judicial review. It was held that Inland Revenue had actually not acted outside their authority, and so on this basis as well, there was no standing for the National Federation to even bring a case in the first place. So Lord Wilberforce considered that the questions of a matter of fact as to whether or not you have a sufficient interest also hinges on and also is determinative on the basis of the conclusion that would ultimately be arrived at in relation to judicial review. Lord Wilberforce says, quote, "As a matter of general principle, I would hold that one taxpayer has no sufficient interest in asking the court to investigate the tax affairs of another taxpayer or to complain that the latter has been underassessed or overassessed. Indeed, there is a strong public interest that he should not on this principle apply equally to groups of taxpayers. An aggregate of individuals, each of whom has no interest, cannot itself have an interest." So essentially what we see here is the extrapolation, firstly, from the point that it seems as a general principle that one taxpayer shouldn't have an interest in another taxpayer, and to then extrapolate that to an aggregate of taxpayers as represented by the National Federation that also does not make a sufficient interest in the general affairs of another individual taxpayer.